This is amazing. Almost everybody's still here, and nobody's having what my mother used to call a sinking spell. So it's just been wonderful, wonderful talks. And I'm very honored to introduce the final two of these absolutely incredible speakers today. Eliza Organic, a citizen of the Dene Nation, born to the Cliff Dweller clan, joined the Washburn University School of Law in 2004, bringing an expertise in clinical legal education, tribal court practice, and criminal defense in Indian country. Her career at Washburn began with the creation of the Tribal and State Court Practice Clinic section, with its focus on representing Native clients in Kansas tribal courts. Prior to joining the Washburn Law faculty, she was a visiting professor at the University of New Mexico School of Law, where she taught in the Southwest Indian Law Clinic, serving Native American citizens in New Mexico and Arizona. Professor Organic is also a former assistant public defender for the state of New Mexico, where she represented both adults and juveniles. While at the public defender office, she worked in the mental health unit, providing training to attorneys across the state on issues specific to mental health and the juvenile client. Professor Organic earned her JD from the University of New Mexico in 1996. Immediately following her graduation from law school, she co-founded the Minors Legal Resource Center, a grant-funded public interest law initiative that provided basic access to legal advocacy and diagnostic health care services for coal and uranium miners in the Four Corners region of the Southwest United States, including the Navajo Reservation. Professor Organic is the co-founder and co-organizer of the Indian Law Clinics and Externship Symposium, which takes place annually in Indian country. The goal of this symposium is to create a pedagogy and methodology for training law students to practice law among Native people in indigenous communities. She has organized and presented at numerous continuing legal education programs, including those that focus on developing expertise in the practice of law in tribal court settings. She's also been an invited speaker on the Indigenous Stream at the Society of Legal Scholars annual conference at De Montfort University in Leicester, UK. Her scholarship includes articles and other publications on Indigenous peoples' rights and tribal court practice. I present Professor Eliza Organic.
Thank you very much. I want to echo my predecessors who thanked the University of Tulsa and the College of Law. This is the second time I've been invited to speak here, and everybody has been so incredibly gracious that I would be remiss if I didn't thank Bill Rice and Vicki Lemus and Professor Royster, as well as Leslie Scruggs and Barbette Beat, who've been just marvelous. And I really mean that when I say that we're running around so crazy. This is the first time that somebody else has actually taken care of my flights and my hotel, and it was a huge help to me over the last couple weeks. Additionally, I want to echo how humbled I feel being here. I'm very new to this conversation, and so if I want to give you a little bit of background how I began an interest in indigenous rights of indigenous peoples, tell you how I kind of got here, and then I'll go through my musings, which I think takes it down. You can see a little bit. We've moved out of the international framework. We've moved away from the federal framework. And what I want to talk about is the area that I work in most, which is state and tribal relations and tribal courts, where I see most of the work on a daily basis being done. So that's sort of how we'll move through. Sort of using the premise that all politics is local. And I don't remember who said that. So whoever remembers, you get, who said that?
Tip O'Neill.
Tip O'Neill, okay. I want to say that I think that the politics, even with respect to such, to this document, really ends up being a very, very local issue. And I don't want us to lose sight of this in the grand scheme of things. As important and valuable as the grand scheme of things is, those of us on the ground working every day need to remember that we have to bring it back down to the people and work with your tribes and communities to make it a realization. But first, I want to say two things. One is that when I was growing up, my mother, who still lives on the Navajo Reservation, who's 75 years old, is a fluent Navajo speaker and a former Miss Navajo, was very strict with us. And whenever we were sitting in a room with our elders and Natani, she said, "You hush up your mouth and don't talk and just listen." And so I was doing that all morning, and all it did was make me feel like I was 12 again. So I want to say that, and by way of trying to express what this means to be at this conference, to listen to people who actually were there, Andrea and Tim and everybody who worked so hard ahead of us to do this work. And so when I say I've come late, I really have. I didn't start thinking about this until I moved to Kansas in 2004. So when I was a law student, we were learning federal Indian law. We never even talked about indigenous peoples in an international framework. That wasn't part of the conversation at law school when I was there from 1993 to 1996. It began to emerge, and it was sort of out there for me, but I figured, gosh, everybody has told us that we can't rely on international law to support tribal interests, so I just sort of put that by the wayside as a practitioner. And then when I got to Kansas in 2004, what came up in my practice in the clinical program was the issue of the Indian Child Welfare Act. And at that time, the Indian Child Welfare Act in Kansas was still notorious for the Baby Boy L decision, which basically espoused the existing Indian family doctrine. And so it grew out of Kansas. It was a state that I was new to, and it was something that was very much practiced in Kansas. The removal of Indian children from their homes because there wasn't an existing Indian family, which was really a sua sponte decision by a sitting district court judge in Wichita. So what happened after that is I found myself increasingly, angry and trying to figure out how I was going to change that decision in Kansas. And it wasn't just me, it was a number of people, and we worked and we went around the state and we began to consider ways that we would inform the judiciary, attorneys, court personnel, CASAs, and people who worked with children about the existing Indian family doctrine and about the principles of the cultural identity of children and how critical it was, and that actually one of the things that we used to bring up all the time as we talked about it, I get on a soapbox regularly, was that the Convention on the Rights of the Child, specifically, and I think Mr. Littlejohn, you referred to this, speaks directly to the cultural rights and identity of indigenous children. And we used to say the only two countries in the world who haven't signed on to that convention are the United States and Somalia, who didn't have an acting government. So 190 countries have signed on. So I used to point that directly to the judiciary in Kansas. And eventually, over a course of 4 or 5 years, I think it was in January of 2009, the Supreme Court in Kansas finally came down and said, we abolish it in Kansas. And so that is, I think, began to make me much more aware of ways to use the international lexicon and dialogue and to have it affect local and state kinds of decision making. And so that's how I got into this conversation. So it was really very late. So while you all had been doing your work for nearly a generation, I just newly stepped into it. But I'm learning from you, of course, as I went along. So what I've been thinking about here, and this is a statement made by Donovan Brown just this last March in Albuquerque, and he says, Native sons and daughters have served in every branch of the United States military and have unselfishly given their lives on foreign soil fighting for the human rights of other people. They should not be required to return to their own lands only to be denied the inherent and fundamental right of self-determination, etc. And this really struck me because he's right. It's 2010. And we are still, what he is saying and what he's feeling and what he expressed in that moment is something that we are still struggling with 200 or 500 years after first contact and 200 years after Worcester, et cetera. We're still dealing with those same issues. And so it really occurred to me that we have to begin to think about this declaration and how to actually use it, using my experience with the Indian Child Welfare Act and the Convention on the Rights of the Child in that language. And so if you notice, the title of my paper is The Declaration on the Rights of Indigenous Peoples as a Blueprint ? The reason I have a question mark about it, I'm going to say it now, it's probably heretical, so we can revisit it later. But one of the things that concerns me a little bit, more than just a little bit, really, to be honest, is that while it's so important and valuable and remarkable that the indigenous voices that were brought to bear that changed the international community's thinking on indigenous people's rights cannot be underscored enough. I think that when I deal with tribes on an individual basis, what I ask myself all the time is this something truly coming from a tribe or people? Are they just taking on another Western framework by which they are codifying their laws and making new laws? And how this came to bear in my in thinking was I was asked by one of the local tribes in Kansas to participate, to come to the council because they were trying to put together a brand new juvenile code. And what they were doing with the juvenile code was they were looking at the state code of Kansas and trying to take it on whole cloth. And it was so upsetting to me because it's not a very good code to begin with. It's not supportive of children's rights in general. It really undermines children's rights, and it does nothing whatsoever for the rights of indigenous children. And so I thought, wow, this is marvelous. You've got an opportunity to completely create something that is inherently and from the grassroots, from your tribe, and really do this the right way. Because when the tribes, began to put themselves together and reorganize under the Indian Reorganization Act, as you know, many tribes took on the constitutional framework that was foreign to them. They took model codes as they were building their tribal court systems. They took on model codes that really weren't something that came indigenously from their own communities, and they did that for a lot of reasons that made sense at the time. They didn't have the expertise. They didn't have the money. They were under pressure to come up with a transparent framework for making legal decisions that affected their citizens. And so, we understand why that was done then, but now is now. And so I was really, waving that flag. And of course, they were very gracious, but it was really met with a lot of silence because the tribal attorney is very busy. There was just two of them, and they were very busy dealing with all the other issues that were going on in the tribe. So she calls me a few months later and says, well, I found the Acoma Juvenile Code, the Acoma Children's Code. And I said, well, okay, that's a start, but it's still Acoma. You can't compare what's going on in Kansas, which is has its own laws and its own issues out in Kansas, and you can't just bring that into a different and wholly different tribal community. So I think I lost that battle because I think they're coming out with their tribal code. So onto their juvenile code. And I'm glad that they are, and I think it's really important, but it's just another soapbox that I hope that we can try to remember that it is invaluable to get on, even in the face of a lot of resistance about that. So that's one of the reasons why I have a question mark there, because even though this was created with the voices of indigenous peoples, it still is a very Western framework for that I think we should make sure we question how we bring that to life. So as we all know, and this is going to be really short because everybody has talked about this before, we know that it's been 3 years since the declaration has passed. We know that there have been some changes, that is, New Zealand and Australia have endorsed it, and that's a really positive thing. We also know that there is work being done right now in the United States, so that maybe there will be some change to the original rejection of the declaration, and so those are really good things. But despite the historic framework for indigenous human rights that was articulated in the declaration, I think that what I hear all the time and what my students ask me all the time is that this is just an aspirational document. What are we supposed to do with it? And I don't know if those of you who've worked in this a long time have heard the same thing, but I kind of try to tell them, well, implementation, of course, is a challenge for these issues. We know that. We've talked about it earlier today. But what I say is that even though we have to have aspirations and we have to set the bar high if we're ever to get anywhere. So the fact that it's an aspirational document is okay, and it shouldn't deter us from using its principles and language to support the interests of tribal people. And so while there is no doubt that we have movement on it, there is, with the current administration being completely beleaguered by all kinds of other things, I really wonder, I feel that they have to do it right if they're going to do it. And so I would almost be a little anxious that they would not give it the full investigation, the full thought, the full meaning of an endorsement. I mean, I really want them to be careful about what they do. So while I want them to hurry and do it as well, I worry about that a little bit. And I also think that we deserve more as Indigenous peoples than to have something given short shrift. We've been waiting a long time for unfulfilled promises, right? And so I don't think that, so at the same time, I think there's a tension. We want to make sure that it gets done right when it gets done, if it gets done at all. So in the face of this reality, I would ask you to consider what tribal communities should do next. How can U.S. tribes bring the Declaration to life in their own communities? I think this is a very real and important question that we should take back to our leaders and to our citizens. We have this framework, a lot of thought and energy and time has gone into it. So what are we going to do with it now that it's out there? Should tribes continue to spend the time getting the federal government to endorse it, or should they work on the ground and instead of waiting for the federal stamp of approval on it, should we just do this in our own communities? Should tribes instead limit their focus to creating the conditions that transform these aspirations into concrete realities on the ground? And I think the answer to that is yes. And also, are there ways to more directly and meaningfully impact tribal communities in a positive way by using the blueprint that the Declaration has provided to us to re-envision tribal-state relations? And the reason that I bring the issue of tribal and state relations into this conversation, going back to all politics is local, is that as we know, that relationship is much more dynamic, much more fast-moving, and much more concrete to tribal people on a regular basis. I think that as I was researching this paper, one of the things that I looked at was all the different tribal cooperative agreements that currently exist, and you can see there's law enforcement agreements, tax agreements, child protective agreements with respect to foster care, land claims agreements, there's jurisdictional conflicts that are resolved by agreement, there's gaming, there's trash collection. I mean, the list goes on and on and on. And so I began to consider that what we should be thinking about is, in using this language, is having it be more immediate. And that we don't have to wait for the government to put a stamp of approval on it. We can start using the language and using the principles on a daily basis within our tribes and tribal communities to make it real and to bring it to life in a very meaningful way in probably much shorter amount of time than maybe some federal legislation. Now, I say this even though I know that there is a history of tension between tribes and states. And I know that, we have hesitated for a long time to make agreements with states because they haven't had our best interests in mind. But I kind of think that is changing a little bit. And I think that is changing, that the evidence of that is in all of these new agreements that I'm seeing being used, and used, I think, quite effectively. And I want to give a couple of examples. One of them, actually, that I saw online that was interesting actually came from the state of Oklahoma, so I thought I'd share it since we're here. And that actually goes back to 1989. It was the National Conference of State Legislatures, a meeting that was here. And the title of that conference was Promoting Effective State-Tribal Relationships, and I change it now to Tribal-State Relationships just because I like that. And one of the things that was described in that agreement actually were the accomplishments that had preceded it. And one was that there was a formal recognition by the state of Oklahoma tribes, state authorization of the tribal state agreements, and the institution of joint relations committee that was there to work on these tribal state relations all the time. And I think that is where you begin to have a really meaningful dialogue. If you've got that foundation in place, that's where you begin to really are able to incorporate the language and principles in a way that is maybe non-threatening because you're there having a conversation, right? It's where we're working on agreements, and in the spirit of working on agreements, you can bring in some of the language. Additionally, moving on just a few years now, the indigenous organization known as the National Congress of American Indians also took a very specific time to address what the issues of tribal state where we were with our state of tribal state relations, and they also urged states and tribes to think about these mutual interests that they have because they share citizens in many respects, and so they urged tribes to work with states on these issues and to move with that government-to-government relationship in these agreements, and they believe that it would be more effective. And so because you've got an organization that is is a big organization, lots of people involved, that has some clout and some power, I think it's important to sort of say, well, you said we should do this, so let's do it. And that is one of the important projects that they continually have. And if you look at their website, they've got a long list of ways that they support tribes in putting these interests together. So I believe it's true that we have much work to do, particularly in places where maybe it's a little bit more remote, or maybe the relationship between the state and the tribes is more fractious. And I think that in some states they're coming along. There was a listening session recently, the one that statement came out of in Albuquerque, and at that time, Zuni, Acoma Pueblo, Havasupai, Dene, they came together. They talked about really important issues such as the mining concerns that are going on. That was an important issue. They talked about native lands and the issues of water rights, which is a big issue in the West, so they came together to bring that to the fore to state officials in New Mexico. They talked at that time about state permits and federal permits, so they're beginning now to really engage the states in these very important issues that affect them fundamentally, water and mining interests. And they talked about, at that listening conference, the historic kinds of human rights abuses that had occurred out at Navajo with uranium mining and the pollution of the waters and actually taking of a lot of water that was being sent down to Phoenix eventually, right, in the Colorado. And so we have this consciousness that is being raised on these levels, and I think it's important to continue to do that in very meaningful ways. I want to give you an example of something that I came across in my research, and it was a 2003 Four Corners Institute white paper, I guess is what you call it, and it was on tribal state relationships and relations between the Navajo Nation and some of the other tribes and a state road that they were trying to build. And what they did before they just kind of pushed through the road was they got together people to talk about, in the tribal communities, to talk specifically about how that road was going to affect the tribal communities. And historically, that isn't something that was done to a very great degree. But what's important about the discussion in this white paper was specifically how it was going to affect privacy and how it was going to affect specific cultural ceremonies that took place during the year. So it's not something that happened on a daily basis, but how was this road going through going to affect the ceremonies that took place 2 or 3 times a year. And in that report, actually, there was an acknowledgement by the folks who wrote this white paper, talking about the critical importance of maintaining the cultural significance of those days and how it was really important that the relationship between the state and the tribe was preserved by ensuring that they continue to respect those days. And so when I see that, I see at least some development of a consciousness and appreciation for what is unique about the tribes in the state, from the state perspective, about their own tribes. So that tells me, I think, that we are making progress, and I think I'm quite grateful to see that. I will add that these were not lawyers who wrote this white paper. It was actually a group of anthropologists and ethnologists and people who were called in to advise the state. And so that brings me to something else, which is I think in the legal framework we tend to sort of be very closed off in our thinking around it. We really need to reach out to other disciplines to help support and buttress our positions with respect to what is sacred to us and what's important to us as a people. It's all very well and good to think like a lawyer, and you're learning to think like a lawyer and be out there and make these arguments and make these fights, but I think we can't forget to engage people who can really help us in that discussion and those dialogues. And so that was one of the things that was quite important about that. And actually, when I looked at that white paper, it fell completely into line with Article 8. And so this was done quite before Article 8 was, before the Declaration in 2003. So you can see that one of the things that would be important to do as you begin to make your arguments and buttress your arguments in a legal framework is go back and see what has already been done that acknowledges this and say, well, wow, you all did a great job because you acknowledged and you are so thoughtful and you're so good at thinking this way, so keep doing it is one other thing that we can do. Also, similarly, what I found this summer was a statute in the New Mexico State Code that deals with the issue of an Indian child. And it talks about when an Indian child is at issue with respect to a SINC or child in need of care petition. This is in the state statute. So what that tells me is there's a lot that can be done on the state legislative arena that really supports what we believe to be incredibly valuable to our children. And we can also now, I have to say that New Mexico hasn't always complied with its own law. So you still have to hold their feet to the fire, but at least it's there legislatively. And I think this has a lot to do with the work of my dear mentor, Christine Zuni Cruz, who thought about these issues and took the opportunity to go to the state legislature and remind them that there are Indian children in the state and we need to protect their interests. But when you have that as part of your statute, when you have the Convention on the Rights of the Child, and when you now have something like the Declaration on the Rights of the Child, even though you're not citing it as precedent, you certainly can make an argument to a state court judge about all the reasons why they need to comply, and so you can really begin to build your arsenal of legal arguments there. Let's see here. I also wanted to make a comment, and I think, Joshua, you're going to speak to this too, that we can push our state and city municipal environments and councils to take on and take a look at the Declaration. The state of Maine has endorsed it. The city of Berkeley has endorsed it. The city of Phoenix has also endorsed it. And so what that tells me is that if that's in their language, we can use that when we go to protect our citizens who are incarcerated, when we go to protect our citizens, our children who are taken into care. We can use that when we talk about roads and encroachment on rights, because they've already used it. So use what you've got on a local level and say, listen, you guys said this, and I believe you mean it. So let's make sure that that works. That's a very important thing. And I don't know, I'm going to turn this over to Joshua in just a minute, but I do want to say that while we're all looking forward to, the stamp of approval from the federal government, and we hope that it comes, because I think it would do a lot to heal the wounds that we have. It by no means should be the end of our conversation. It should just be the beginning of our conversation. I think we've heard that over and over and over today. But I want us to be really creative about how we use it, and not to be afraid to use it in our arguments, not as precedent, but as support for the principles, and that also to go back to your tribal officials and say, let's just make it so. Because if it's so, and if we use it on that level, then when we can incorporate those principles into our memorandums of understanding, into our contracts, into our negotiations with states, and what we're not willing to give up are those rights that we believe that are inherent to us, as well as what is espoused internationally. So I think that's it for me, Joshua. Suffrage, yeah. Okay. Oh, yeah, this is just one little thing. I want to just say, give a shout out to Shin Amai from Osgoode Hall at the University, Osgoode Hall in Canada. He really talks about this, which I like a lot, which is the co-institutionalized Indigenous participation piece of it, which really is just is a fancy way of saying, let's just get in there and make it a regular part of our conversation when we engage in mutual agreements. And I really like that language because this issue about institutionalizing it makes it more real. Thank you.